why this is important? Because IP rights is probably the main asset of a startup company, of a tech company. And if you seek for an investment, or if you plan to seek for an investment, you want to make sure your IP is crystal clear. Outsourcing often comes, however, in a very early stage of the company's life, sometimes before the company have decent legal advice, and therefore the interpreters themselves need to be involved to make sure they get the right legal advice to do that. I will speak about a few points which are related to this topic, which you can see here in the agenda, and then I will get to the last one, which is actually a few key matters or a few ideas which should be included into your outsourcing agreement and the way how you work with your outsourcing provider. So before we go into this topic, let's see how what can happen to your IP and how this works sometimes. So let's imagine ourselves, we have an Israeli company who signs an agreement with a Serbian outsourcing company. Just an example. Then often the Serbian outsourcing company will send the work to be done by some independent developers or subcontractors, for instance, in Czech Republic. Now, let's imagine ourselves that the Czech Republic, this subcontractor violates the IP right and send the information or the code or whatever to your Chinese competitor, who sells it legally to European client. Now, what would be the law and the jurisdiction which will apply to this situation? Where and which country would you like to sue and whom? It's not a very simple question. And we'll get back to this theme and talk about it later. But our agreement controls the relationship between the Israeli company and the Serbian company. It can indirectly influence the relationship between the Israeli company and the Czech developer, sometimes, usually not. But it definitely has nothing to do with Chinese competitor and an European client. I will leave this point open and move on, and we'll get back to it in some different aspects. So a core part of any agreement is your NDA, non-disclosure agreement, which usually includes the obligation of the outsourcer provider not to disclose your confidential information, not to use it for any other purpose except for providing your services, and to take a reasonable degree of care to make sure this information is not reach unwanted hands. But will this NDA prevent a leak of IP? And the answer is obviously not, because no agreement will prevent the Czech subcontractor to send an email to the Chinese competitor. All right. So if the NDA does not prevent leak of IP, so why do we need it? There are two reasons which people usually don't think about, but they are super important. One is patentability. An invention is patentable, which means you can write a patent on an invention only if it was not publicly disclosed before filing the patent application. Disclosure of IP without NDA will often make the invention unpatentable. I mean, you send something out without an NDA, and you might be not able to apply for a patent, and if you get a patent, you might be not able to enforce the patent. The other way to protect your IP rights is trade secret. Trade secret is an information which, among other things, owner makes reasonable effort to maintain its security. Disclosure of information without NDA will often make the trade secret non-enforceable. It means it will show that you never protected it and therefore it's not secret. IP ownership. Well, the ownership of the IP which you share with your outsourcing contractor is probably the core of any outsourcing agreement. Now, getting back to RSM, outsourcing agreement is between Israeli company and the Serbian company here. And here is a situation where it's very clear what is the applicable law, Israeli and Serbian. Therefore, IP ownership clause must be based on applicable law, because different law and different IP rights, such as copyright, trade secrets, patents, and so on, they require different agreement coverage. For instance, sometimes we write in the American agreements that the work made by the outsourcer provider is work made for hire. But under the Ukrainian law, work made for hire may sometimes means that you have that the outsourcer provider and the company share the rights in the IP, which were created by the outsourcer. So this is probably not what you usually mean by work made for hire. So you must take into account the law of the country where your outsourcing provider is based. When we talk about code and program outsourcing, we must address the use of open source, because sometimes when you use open source, you will not own the right in the IP, or you have to publish your new code and so on. So you want to make sure you know whether your outsourcing provider use open source or not, and covered with your agreement. And another important point is undertaken by the outsourcer provider to avoid usage for third-party IP. You cannot supervise it, but in case the outsourcing provider will use a third-party IP, at least you will have the agreement to protect you and to prove that you did not know about this infringement. Personal data outsourcing. Transfer of personal data to outsourcing companies, such like data about patients or about clients, especially to other countries, is always an issue. In recent years, we got the GDPR, the Israeli regulation, the USA recent regulation, which is changing all the time. It's often in US, it's often a state-based regulation. So different states has different regulation, it changes all the time. Made this matter of personal data security and processing a very complex issue. In the past, I remember that I used to advise clients about those matters. I don't anymore, because they require a very specific expertise. And if you have a lawyer who supervises this kind of project, you want to make sure he has someone involved who has expertise in this particular issue, in not only in your country, but also in the country of residence of the outsourcer provider. Needless to say, of course, that I have a partner in my firm who is expert in this field. Another point which I think is important is that management always works better than legal tools, because it's always better to prevent a fight than to win it. You want to make sure your rights will not be violated. You don't want to enforce them in the court, among other things, because it is too complex and too costly to be dragged to litigation in a foreign jurisdiction. So First, it's of course about choosing the right partner and making a good background check. Second is getting into a situation where you can on an ongoing basis manage how your IP and your confidential information is handled by your outsourcer provider. It requires business understanding of how and what he is going to do. It requires the technology which will make his work transparent, and it requires the contractual provisions which will allow you to audit. After we discuss those points, let's just summarize by talking about a few points which are relevant for outsourcing agreement. So professional background check, any contact, proper NDA, as we talk about, who will keep your IP patentable and your trade secrets enforceable. The ownership IP clause must be based on the applicable law, not only on the law of the contract, but also on the law of the jurisdiction where your outsourcer provider is based. You want to have an audit clause in the agreement, which will allow you to audit your outsourcing provider and the way it handles the confidential and proprietary information on an ongoing basis, hopefully with technological means. You want to make sure technologically, or at least contractually, that the access to your IP is limited only to pre-approved subcontractors and employees. Pre-approved means that your outsourcer provider goes to you and asks, can I share it with this and this and this individual? Conflict of interest. Every outsourcing agreement usually get to discussing, can the outsourcing provider work with your competitors? And you need to think, how can you define who your competitors are, maybe made by field, by client, by technology, and I won't get too deep into it. Change of control clause. Do you remember the background check? If your outsourcer provider changed the control, which means the company is sold to someone else, probably you want to make a new background check. So you want to have a clause in the agreement which will make your outsourcer provider to inform you when there is a change of control. In case of bilingual contract, it means an agreement which is made, for instance, in Russian and in English. Usually this agreement will, in English, it will say that the English text prevails. However, please read the other language as well, because sometimes the other language will say that Russian language prevails. And anyway, a Russian court, as an example, will read the Russian language. They will not bother to listen to your claims that in English it says something else. And make sure that while you are represented by local, for instance, Israeli attorney, your lawyer at least consults with a local expert in the jurisdiction where your outsourcer provider is based, because as we just mentioned a few times during this presentation, there are questions which need to be addressed according to the local law of the outsourcer provider. So basically, this is it.